Welcome to our first virtual event. As the founder and chairman of the LSLC, I must tell you, it never ever crossed my mind that in the life of the LSLC of over 25 years, we would end up in this situation of not being able to see you. But in this brave new world, the LSLC is up to the mark and ready to adapt. We all hope, however, that digitalization will not take over the community element the LSLC offers to the maritime sectors and the legal fraternity. I'm very pleased to welcome all of you, and in particular, the many new participants from all over the world joining us for the first time. We are 300 behind the scenes. Undoubtedly, it is an advantage of digitalization that we can reach out to you in any country of the world. I hope you will continue to benefit from the work of the LSLC in the future, and we look forward to meeting you in London. As I said, the LSLC is a community of the maritime, commercial, and legal sectors. As always, the LSLC is privileged to have distinguished panelists chaired by eminent members of our judiciary. I welcome and thank Sir Robin Knowles, who has chaired our events before, and also our panelists, Francis, Sherina, James, Duncan, who will be introduced by the chairman. I would just like to thank 36 Stone, particularly Vasandi Salvaratnam QC, for their staunch support. And we are, of course, grateful to Norton Rose Fulbright for lending us their facilities to stage this Audio Simu-Live seminar. With this particular technology, however, you will not see the speakers, but only their slides. Special thanks are due to Sherina Petit, Grace Chamberlain, and Charlotte Winter of Norton Rose Fulbright for a sterling job to prepare this event together with LSLC. The subject of enforcement of arbitration awards is of huge importance, and as an arbitrator myself, my mind hovers over the enforcement of the award, which I'm going to write, from the appointment and at every stage of the proceedings. Enjoy, and I expect you will have many questions to ask during the Q&A session. Thank you very much.
Good afternoon and hello from Bath. My name is Francis Strickland and I'm going to talk about 3 cases today that in their different ways touch on recognition and enforcement of arbitration awards. The first is the now infamous 2010 case Dalla and Pakistan, and off the back of that I'm going to explore 2 Court of Appeal authorities, Kabaji and Coop Food Group and Enker and OOO, both of which are recent 2020 judgments. Both Dalla and Kabaji relate explicitly to the question of recognition and enforcement of foreign arbitral awards in England and Wales, but all 3 share a concern with the governing law of the arbitration agreement. And the Enker judgment is relevant in that regard, in that it has changed the law quite significantly and will in turn likely have a significant impact on questions of recognition and enforcement going forward. By way of brief recap, arbitration agreements are separable from the underlying contract of which they form a part. Accordingly, that means they can have a separate governing law, and in cases where the arbitration agreement itself doesn't explicitly address what law is to govern the arbitration agreement, this can lead to competing arguments about what law should apply. This is particularly likely in scenarios where the law governing the main contract is different from the seat of the arbitration, as there are then at least 2 different laws that could arguably govern the arbitration agreement, the law of the contract or the law of the seat. Arbitration being a creature of contract, the question of what law should govern the arbitration agreement is essentially one of contractual interpretation. But determining the party's objective intention in this regard can be a bit of a Delphic exercise when there is little in the contract to guide a tribunal or court. Yet determining what law governs the arbitration agreement can have profound effect on the arbitrability of certain types of disputes, as some disputes are arbitrable under one law but not under another, so the question can have very material implications. When an arbitration award has been rendered in one jurisdiction and the issue develops to one of recognition and enforcement in another jurisdiction, this also raises a comity question. If a party resists enforcement in the second state, who should decide what law governs the arbitration agreement and the effect of that law? Should it be the tribunal and/or the courts of the seat, or should foreign jurisdictions where the law is sought to be enforced have a right to reopen the question? This last question reared its head infamously in Dalla and Pakistan, and it's to that case that I want to turn first. You'll find a simple diagram of that case on slide 4 of the PowerPoint. On its surface, Dalla was a straightforward case. A Saudi company, Dalla Real Estate, entered into an MOU with the government of Pakistan to provide housing in Saudi Arabia to Pakistani pilgrims to Mecca. Pursuant to that, the Prime Minister of Pakistan set up the Awami Hajj Trust, a separate legal entity with which Dalla ultimately contracted for the development of a housing project. That contract contained an arbitration clause providing for ICC arbitration in Paris, but it didn't contain a governing law clause. The contract was ill-fated and lasted a mere 3 months before the trust ceased to exist, because the old Pakistani government of Benazir Bhutto was overthrown and the new government of Pakistan refused to renew the contract and purported to terminate the agreement. Dalla then sued the Pakistani government for repudiatory breach and claimed damages. The Pakistani government, for its part, refused to engage in the arbitral process and made it clear that it contested the tribunal's jurisdiction and maintained sovereign immunity. Now, the ICC tribunal in Paris found that the governing law of the contract and the governing law of the arbitration agreement was French law, and that under French law, Pakistan, and not merely the trust, was a party to the arbitration agreement. Part of that decision was based on applying French civil law principles of good faith, and also by considering the pre-contractual negotiations of the parties, which demonstrated that the Pakistani government clearly viewed the contract as its own, despite it being in the name of the trust. While appeal proceedings were ongoing in Paris, Dalla sought to enforce the award in England, and the Pakistani government sought to resist enforcement in England on the basis that there was no valid arbitration agreement between it and Dalla, because the trust and not the Pakistani government was the contracting party. As to that question, the English Supreme Court accepted that French law governed the arbitration agreement, and accordingly it applied French law to the question whether there was a valid arbitration agreement between the parties. However, somewhat controversially, the Supreme Court came to the opposite conclusion of the French First Instance Court as to whether Pakistan was a party to the arbitration agreement. The English Supreme Court held that Pakistan was not a party to the arbitration agreement and refused recognition and enforcement. To add insult to this, 2 months later the French Court of Appeal upheld the French lower court's decision that Pakistan was indeed a party to the arbitration agreement. This resulted in the English and French courts reaching opposite views. That obviously raises significant comity questions. What on earth, one might ask, was the English Supreme Court doing, usurping the French court's function as the best court best placed to determine whether under French law Pakistan was a party to the agreement? I don't intend to rehash the nuances of the Supreme Court's decision in detail, except to say that there were two key criticisms of that decision. First, Article 6 of the New York Convention and Section 103, subsection 5 of the English Arbitration Act provides enforcement courts with authority to stay or adjourn decisions on enforcement proceedings pending the outcome of annulment proceedings in the arbitral seat. Critics of the Supreme Court's decision argue that the purpose behind Article 6 is to ensure that there is respect for legal comity and that it was designed precisely in order to avoid conflicting judgments in different jurisdictions. In short, it was designed precisely to avoid the kind of situation that arose in Dalla. Pursuant to those provisions, many commentators argued that the UK Supreme Court clearly should and almost certainly should have adjourned the enforcement decision until the Paris Court of Appeal had heard the annulment proceedings. And secondly, those critics argued that the English courts hadn't properly applied French law principles, otherwise they would have arrived at the same conclusion as the French courts, namely that Pakistan was a party to the arbitration agreement. If I could ask you to turn to the 5th slide, to Kebabji and Koot Food Group now. The recent 2020 case, Kebabji and Koot Food Group, is similar to Dalla. Like Dalla, there was an arbitral award issued by a Paris-seated tribunal. Like Dalla, there was a question whether the respondent was in fact a party to the arbitration agreement. Like Dalla, the tribunal held that the respondent was a party to the arbitration agreement and rendered an award against it. And like Dalla, the English courts refused to recognise and enforce the award. But there the similarities end. In Kebabji, there was an express choice of law clause governing the underlying contract, and that was English law. So already the gravitational pull towards England was stronger. It also meant that because there was an express choice of law clause governing the underlying contract, that the English courts did not necessarily have to apply French law principles in determining what law governed the arbitration agreement. In fact, there was a strong argument to say that although the seat was based in Paris, the fact that the governing law of the contract was English law indicated an intention for the arbitration agreement to be governed by English law too. Accordingly, when we begin our line of questioning, there is a strong argument that the English legal system should frame the questions. The fact that you have a Paris-seated arbitration with an English applicable law clause can result in a tug of war as to which a legal system should frame the questions you ask for how you determine the law governing the arbitration agreement. And that tug of war raises intriguing conflict of laws questions for which there is no obvious answer. But without even straying into international territory, the English case law on its own demonstrates this tension. For instance, in the 2007 judgment C and D, Lord Justice Longmore opined that in the absence of an express choice of law clause governing the arbitration agreement, the law governing the arbitration agreement is likely to be the seat of the arbitration. However, by contrast, in the 2012 judgment Sul America, Lord Justice Moore-Bick explained that in his view, where the arbitration agreement forms part of the substantive contract, an express choice of law to govern the substantive contract is, and I quote, an important fact to be taken into account and likely to lead to the conclusion that the parties intended the arbitration agreement to be governed by the same system of law as the substantive contract, unless there are other factors present which point to a different conclusion. And in the 2016 Singapore High Court case BCY and BCZ, the court, drawing on Sul America, went further, opining that the governing law of the main contract is a strong indicator of the governing law of the arbitration agreement, unless there are indications to the contrary. The choice of seat, different from the law of the governing contract, would not in itself be sufficient to displace that starting point. So even within the UK and other common law jurisdictions, there is a tension as to what law should govern the arbitration agreement, where there is no express choice of law governing that arbitration agreement. In Kebabji, however, the Court of Appeal sidestepped these difficult conflict of laws questions by deciding that as a matter of contractual interpretation, the governing law clause of the main contract was intended to apply also to the arbitration agreement. Accordingly, there was an express choice of law clause governing the arbitration agreement, English law, and that under English law, Coote Food Group was not a signatory to the contract, and the rights and obligations had not been novated to it. One of the interesting points made in that judgment was that while an arbitration agreement is separable from the underlying agreement, that didn't mean it should be interpreted as part of it. It shouldn't be interpreted as part of it. The point of separability is to enable the arbitration agreement to still function where there are concerns the main contract has been vitiated by fraud, for example. But that doesn't mean it should not be interpreted as part of the whole contract for normal contractual interpretation questions. In this instance, the court held, on an application of clauses 1 and 15 in the Kebabji contract, the governing law clause in the main contract was intended to apply to the entire contract, including the arbitration agreement, and therefore, as a matter of contractual interpretation, there was an express choice of English law as the governing law of the contract. Under English law, there are, of course, 3 different routes to determining the applicable law of an arbitration agreement. First, the courts ask whether there is an express choice, and if not, the courts move on, secondly, to ask whether there is an implied choice of governing law, and if not, the courts then move on to a third question, which is to ask which law the arbitration agreement has its most close and real connection with. In Kebabji, the court held it never needed to move on to question 2 or 3, the implied or closest connection test, because as a matter of interpretation, there was an express choice of English law. This is a neat decision, which on its surface sidesteps most, if not all, of the decision difficulties that plague the Supreme Court in Dalla. However, what if we asked the Article 6 New York Convention question? Should the English courts have stayed or adjourned the enforcement proceedings and waited for the outcome of the appeal in the French Court of Appeal? Indeed, if the English Supreme Court in Dalla felt comfortable interpreting French law, should it not also have had the same confidence in the French courts coming to the correct conclusion in reverse? The answer to that question is moot, but it demonstrates that the English courts are not afraid to flex their territorial or jurisdictional muscles when it comes to the question of which country is best suited to answer a conflict of laws question. Merely a month or two later, just a few weeks ago, the Court of Appeal handed down yet another decision on the correct approach to ascertaining the governing law of an arbitration agreement, Enker and O. That case doesn't directly address questions of recognition and enforcement, but it does address the correct approach to identifying the governing law of an arbitration agreement, and in doing so makes some rather dramatic changes to the law. In short, it seems to me to be flatly inconsistent with the earlier leading judgment Sul America. In Enker, the court accepted the position in Petit, i.e. that as a matter of contractual interpretation, the parties may intend an arbitration agreement to be governed by the law of the main contract, and that such a choice could constitute an express choice under Lim 1 of the test. But if there was no express choice of governing law and Petit didn't apply, then the court has to determine whether there is an implied choice of law governing the arbitration agreement. As to which, as we've already seen, the old Sul America judgment explained that where there is an express choice of law governing the main contract, that is likely to lead to the conclusion that there is an implied choice that the same law governs the arbitration agreement. Further, in BCY and BCZ, the Singaporean courts went further and opined that a choice of seat different to the law governing the contract is not sufficient to displace the presumption that the law governing the contract should also govern the law of the arbitration agreement. In my view, that makes commercial sense. Parties do not readily agree for different laws to govern different parts of a contract. But, somewhat oddly in my view, Lord Justice Flo's decision in Enker now says precisely the opposite. Of course, Lord Justice Flo wasn't bound by the decision in Singapore, and the Sul America case was made in the same Court of Appeal, but the judgment is in some respects surprising. The background of the dispute is that Enker and O had contracted for the provision of services to build a power plant. The contract was governed by Russian law, but provided for arbitration with the seat being England. A dispute arose, and O sued Enker in the Russian courts, arguing that the governing law of the arbitration agreement was Russian law, and that under Russian law, the dispute in question fell outside the ambit of the arbitration clause. O argued that English law governed the arbitration agreement, and applied for an anti-suit injunction against the Russian proceedings. When addressing that question, Lord Justice Flo determined to resolve the case law in this area. Indeed, at paragraph 89 of the judgment, he explained that in his view, the current state of the authorities do no credit to English commercial law, which seeks to serve the business community by providing certainty. But in stark contrast to Sul America, he resolved that where there was no express choice of law governing the arbitration agreement, if there is an express choice of seat, the law of the seat will almost always be the law governing the arbitration agreement, rather than the law of the substantive contract. Lord Justice Flo gave three reasons for his decision, which I'll take in turn. They are, first, that there is no principled reason for treating the governing law of the contract as determining the law of the arbitration agreement. As to that, I'm not sure that's really the right question to ask. There is certainly a commercial reason for leaning towards the arbitration agreement being governed by the law of the underlying contract, and that is that commercial men and women, as I say, don't readily intend for different laws to govern different bits of a contract. Second, Lord Justice Flo opined that the scope of the curial law and that of the arbitration agreement overlapped, because the curial law was not limited to questions of a purely procedural matter, but could affect, in certain circumstances, the substantive rights of the parties. While that is certainly true, I don't see this as justifying in any way a departure from point one. It just reiterates that there is a choice to make, as to which I revert back to the justification given in point one, that commercial men and women don't readily intend the law governing an arbitration agreement to be governed by different laws to the law of the substantive contract. Thirdly, Lord Justice Flo regarded the question of whether the seat should govern as one of implied choice under Lim 2 of the test, not the closest and most real connection test under Lim 3. While I can accept that, I again fail to see how that indicates that the law of the seat should prevail over the governing law of the contract. It just suggests to me that you're left with a choice. This leaves us in the odd position of having two conflicting authorities, both from the Court of Appeal, Sul America and Enker, which say precisely the opposite in determining whether the governing law of the contract or the law of the seat should prevail. The Enker judgment also begs the question whether the only circumstances where one will ever need to rely on the third limb of the test is where there is no choice of seat, because it now seems to be the case that where there is a choice of seat, that is the law governing the arbitration agreement. Drawing these strings together, both the Kababji and Enka judgments, in their different ways, are likely to have repercussions for recognition and enforcement proceedings where companies try to enforce arbitration awards in England, but are faced with applications resisting enforcement and recognition on the basis that the tribunal reached the wrong conclusion regarding what law governed the arbitration agreement. That is because the answer to that question may in turn result in parties being regarded as non-parties to the agreement and or certain disputes being arbitrable or not arbitrable, as the case may be. It remains to be seen whether the Enka judgment is appealed to the Supreme Court, but it does seem ripe for the question to be clarified in order to reconcile Enka and Sul America. In my opinion, the law is now arguably less clear than it was previously. Now we have two competing Court of Appeal authorities that provide flatly opposing ratios. Thank you for listening. I now hand over to Sherina Petit from Norton Rose Fulbright.
Thank you, Francis. Good afternoon, everyone. I am Sherina, Petit, partner and head of the India practice at Norton Rose Fulbright. I'm delighted to be here today, and I thank the London Shipping Law Centre for their kind invitation to co-host today's webinar. I know we only have about 10 minutes today, so my presentation will be brief and touch upon key points relevant to the enforcement of foreign arbitral awards in India, a topic that could actually take days and months to discuss. The underpinning theme of this presentation is that things have improved. They've actually improved quite significantly over the past years. It is clear that there still seems a lot of work to be done, but it has to be said that both the judiciary and the government have in recent years taken a proactive approach to making India a more attractive jurisdiction for foreign investors who demand dependable and efficient dispute resolution mechanisms for the resolution of their disputes. On this slide, I have tried to provide a bird's eye view of the applicable legislative framework in the country. The Indian Arbitration and Conciliation Act 1996 is largely based on the Unstral model law. Put simply, today, Part 1 of the Arbitration Act generally deals with arbitration seated in India, although certain provisions like court assistance in the aid of arbitration also apply to arbitration seated outside India. Part 2 deals with arbitration seated outside India. There has been a series of legislative and judicial decisions which resulted in the Act being amended in 2015 and then once again in 2019. India is a party to both the New York Convention and the Geneva Convention. However, an award is only enforceable in India if it was made in the territory of another state that is identified by the Government of India in the official gazette as being bound by either convention. Saying this, the UK, US, Hong Kong, Singapore, Switzerland, and other popular destinations are all gazetted convention countries. Therefore, an award rendered in a commercial arbitration in a gazetted convention country is enforceable in India. But then again, this is provided that the procedural requirements to enforce an award are satisfied and the award does not fall under any of the categories where enforcement can be refused. The grounds for refusing enforcement of a foreign arbitral award are inter alia largely the same as the grounds set out in the New York Convention. Interestingly, the Indian courts have now held that the grounds for refusing enforcement of a foreign award, including the public policy ground, are actually narrower than the grounds available to challenge an award rendered in India. Further, unlike a domestic award, enforcement of a foreign award cannot be refused on grounds that is patently illegal. Again, the buzzwords from the past. I'm sure you will not be surprised to hear that the enforcement of foreign awards in India has been historically difficult. The courts unfortunately did not shy away from intervening in the enforcement process, including on public policy grounds, or applying parts of the Arbitration Act designed for domestic awards to the enforcement of foreign awards. However, given the recent judgments and legislative changes, India has significantly improved and is inching closer towards a pro-arbitration jurisdiction. I will touch upon two key decisions which shape India's position on the enforcement of foreign arbitral awards. I have set out on this slide some of the key cases where the courts took an interventionist approach and which cast a shadow over the enforcement of foreign arbitral awards in India. Due to time constraints of this webinar, this is not an exhaustive list, but presents some of the main culprits. More importantly, the chronological order of these key cases shows a build-up of anti-arbitration decisions until the breakthrough judgment, which I will discuss on the next slide. The key judgment on this slide is Bhartiya International versus Bulk Trading, the Supreme Court decision handed down in 2002. In the 1996 Act, Part 1 of the Act stated that it applied, and I quote, where the place of arbitration is in India. A three-member bench of the Indian Supreme Court considered whether it could accede to a request for interim measures to an Indian court in an ICC Paris-seated arbitration. One of the respondents had sought interim relief from the court under Part 1 of the Act. The appellant objected that the court had no jurisdiction because Part 1 did not apply to arbitrations in which the seat of arbitration is outside India. The Supreme Court held, and I quote, the provisions of Part 1 of the Act would also apply to international commercial arbitrations seated outside India unless the parties had expressly or impliedly agreed to exclude its application. Sadly, this resulted in a number of cases, some of which are on the slide, which encouraged unwelcome judicial activism. As a result, practitioners and clients alike watched in dismay as Indian courts handed down judgments, such as Venture Global, where the Indian courts held that Part 1 of the Act applied to an LCIA award, and they therefore had the power and jurisdiction to set it aside. I recall at that time getting calls from clients who wanted to renegotiate existing arbitration agreements to expressly exclude Part 1 of the Act. Increased judicial intervention not only added to the uncertainty around the arbitral award enforcement process, but also worsened the procedural challenges associated with using Indian courts, already famously overburdened with cases, which now had to consider whether and to what extent Part 1 of the Act applied to foreign and domestic arbitrations. In short, there was complete chaos. Thankfully, September 2012 was a turning point for Indian arbitration. In a watershed decision, a five-member bench of the Supreme Court delivered a judgment in the case of Bharat Aluminum Company versus Kaiser Aluminum Technical Services, most popularly called the Bagshaw judgment. In this case, put simply, the court clarified that Part 1 of the Act was not applicable to international arbitrations held outside India. However, the judgment left parties without the possibility of seeking interim reliefs in India, as this relief was not available in Part 2. The Bagshaw judgment, although not the cure for all ills, heralded a new dawn for Indian arbitration. I will now touch upon two most recent Supreme Court decisions rendered in 2020 of Vijay Karya and Nafeed, which have recently shaken up the debate about enforcement of foreign awards in India. Vijay Karya offered a pro-arbitration approach and fully endorsed the New York Convention's pro-enforcement bias by recognizing that mere violation of Indian law would not amount to a violation of public policy of India. It is in fact recognized that incompatibility with Indian law is to be in a way expected from foreign arbitral awards, which are decided under international and not Indian rules. Nafeed, on the other hand, seems to have turned back the clock and adopted an interventionist approach. In this case, the court has not only interpreted the contract and reviewed the award on its merits, but also ultimately set it aside on the grounds of it being illegal under Indian law, and therefore against the public policy of India. Nafeed is rightly seen by many as a prime example of judicial activism. To be optimistic, I think that the two cases can be distinguished on their facts, which we do not have the time to discuss today. However, there is a high risk that Nafeed, just like Petit before it, will open up the floodgates for a new wave of interventionist judgments. The decision, although handed down only in April this year, has already been widely criticized. In practice, it remains to be seen what impact it will have on the enforcement of foreign arbitral awards in India. Having looked at the key judgments, it would be incomplete if I did not touch upon the key legislative arbitration changes that had taken place in India in 2015 and most recently in 2019. As I mentioned, Part 1 of the Arbitration Act deals with arbitration seated in India, and Part 2 deals with arbitration seated outside India. However, certain relevant provisions of Part 1 of the Arbitration Act today also apply to arbitration seated outside of India. As we have touched upon, there have been a series of judicial decisions and legislative amendments to make India a more arbitration-friendly jurisdiction. It is important, however, to note that the legislative amendments apply partly prospectively and partly retrospectively. The version of the Act that will apply to a case will depend on the date on which the arbitration was commenced, court proceedings relating to the arbitration, if any, were commenced, or when the arbitration agreement was executed. Importantly, the 2019 amendments restrict the scope of interference by the Indian courts by stating that in an application to set aside an award, the courts can only rely on the materials furnished before the relevant arbitral tribunal. To conclude, the picture for commercial arbitration in India is much more optimistic than it was when the Arbitration Act of 1996 was enacted. As we are approaching its 25th anniversary in August next year, it is fair to say that the courts in India have demonstrated an increasingly favorable attitude towards the enforcement of foreign arbitration awards. This is very much in sync with the Prime Minister's agenda of making India an investor-friendly and an arbitration-friendly jurisdiction. I will now hand over to James Rogers, also a partner at Norton Fulbright, who will speak about the enforcement of arbitral awards in China. Thank you.
Thank you, Sherina, and thank you also to the LSLC for the opportunity to speak to you this morning. Sherina and I have spoken together on many panels on the topic of international arbitration. I have to admit this is the first time I've received a virtual handover in this way, but things have changed, haven't they? We're living in a new world. So the topic of my presentation today is the enforcement of arbitration awards in China. Any discussion of the enforcement of arbitral awards in China has to begin with categorizing the different types of award that you might be dealing with. Depending on the place of arbitration and or the presence or indeed absence of a foreign element in a dispute, Chinese law recognizes 4 distinct categories of awards and treats each of those awards in a different way. There are local awards, those awards which are rendered in mainland China by a Chinese arbitration institution over disputes that are entirely local in nature. There's then foreign related local awards, Now, these are awards which are also rendered in mainland China, so they are Chinese awards, but they have a foreign element, whether it is an international party to the award or perhaps performance of the contract in question took place outside of China. Third, you have awards rendered in the Hong Kong Special Administrative Region, the Macau Special Administrative Region, and Taiwan. And lastly, you have pure international awards. Those are awards which are rendered outside of mainland China or its associated jurisdictions, Hong Kong, Macau, and Taiwan. Now, before pushing on to discuss in more detail the enforcement of awards, I just wanted to pause here for a moment to note a couple of the distinctions that you should bear in mind when arbitrating in mainland China. You'll notice the emphasis in this slide on foreign elements. Now, if there's no foreign element to your dispute, that is, performance of the contract took place in China, and the parties to the dispute are both Chinese parties, then there is a local law requirement that you must arbitrate any dispute in mainland China. And arbitration in mainland China must take place before a mainland Chinese arbitration institute. So there's no ad hoc arbitration and no arbitration before institutions such as the ICC or the LCIA or what have you. And finally, you must also apply substantive Chinese law. Now, this does catch parties out, and it's not unusual to see invalid arbitration agreements, particularly where you have a Chinese entity that is wholly foreign owned. For the purposes of this analysis, that is a Chinese entity, and therefore if it is arbitrating with another local Chinese company, that is a local dispute and therefore must be arbitrated in China. One of the reasons for these different categories is the fact that China is in fact made up of a number of distinct legal jurisdictions. There's the People's Republic of China itself, then the Hong Kong SAR and the Macau SAR are distinct legal jurisdictions. They form part of the People's Republic of China, but they are distinct legal jurisdictions. And lastly, there is Taiwan. Now, I won't get into the politics of Taiwan, but in effect it is also a distinct legal jurisdiction. This has most obvious application when it comes to the New York Convention. The People's Republic of China is a party to the Convention with standard commercial and reciprocity reservations. That is, it will enforce awards from other New York Convention countries, provided they deal with commercial matters and are rendered in countries that will enforce awards from the People's Republic of China. Now, Hong Kong and Macau are party to the New York Convention, not in their individual capacities, but by virtue of the People's Republic of China's own accession to the Convention. Lastly, Taiwan is not a party to the Convention, nor does it have coverage under the New York Convention by reason of China's accession to the Convention. Nonetheless, it applies the New York Convention in spirit through its own local legislation. And this has consequences for the enforcement of awards across those jurisdictions. I can recall when I first moved to Hong Kong almost 10 years ago, one of the first books on the subject of enforcement of awards that I looked to was a book by Michael Moser, a very prominent arbitrator in the region. And I can't recall whether it was 16 different categories or perhaps 32 different categories of different types of awards that he had to consider the enforcement of across the different regions in mainland China. across Greater China. So, for example, he had a chapter on the enforcement in mainland China of local awards, another chapter on the enforcement of local but foreign-related awards, chapter on the enforcement of Hong Kong awards, a chapter on the enforcement of Macau awards, and a chapter on the enforcement of Taiwan awards. In turn, in Hong Kong, there was a chapter on the enforcement of local Hong Kong awards, international awards, mainland China awards, Macau awards, Taiwan awards, and so on across all of the jurisdictions. So looked at that way, it's quite a complex matrix of different regimes. Perhaps made more complex in mainland China because of the special treatment for local awards with a foreign element and those awards of an international nature. And we'll come to that special treatment in a moment. So what regime applies to these different categories of awards? Well, there's local law, of course, the local Chinese arbitration law, which incorporates the New York Convention, which is the relevant regime for the enforcement of international awards. And then when it comes to Hong Kong, Macau, and Taiwan awards, they are subject to their own separate regimes. Not the snappiest titles, but for Hong Kong it is the arrangement in respect of mutual enforcement of arbitral awards by the mainland and the Hong Kong SAR, similarly titled in respect of the Macau SAR. And finally, when it comes to Taiwan awards, there is the Supreme People's Court directives in respect of acknowledgement and enforcement of arbitral awards rendered in Taiwan. So these are three specialist regimes that apply for the enforcement of awards from those different jurisdictions. In essence, they do not differ significantly from the New York Convention grounds. They provide similar means to challenge enforcement, limited, but ultimately subject to public policy. Some might say that, in fact, these regimes provide a quicker mechanism, at least in a practical sense and procedurally, than does enforcement under the New York Convention. Perhaps the most interesting aspect of the enforcement regime in Greater China is the so-called reporting system that applies in relation to foreign-related and international awards. Basically, the system requires that the local court at the place of enforcement, that is the court closest to the respondent party, that local court is unable to reach a decision to refuse the recognition or enforcement of a foreign-related or international award. It can take a positive decision to enforce such an award, but if it decides to refuse enforcement, it must internally refer that case to the next highest court in the Chinese court hierarchy. And in turn, if that higher court concurs with the lower court's decision to refuse enforcement, it must also refer the case to the next highest level, and so on until the case reaches the Supreme People's Court. In other words, it is only the Supreme People's Court that is able to refuse enforcement of foreign-related or international arbitration awards. Now, it's fair to say that this process is somewhat opaque. There are time limits on the lower court to reach its decision. I believe that's 2 months, but there's no similar time limit on the Supreme People's Court to reach its decision, nor is there any consistent procedure in terms of making submissions to the intermediate courts throughout the process. So in effect, the award goes in for enforcement in the lower court. That court may then refer the award up, and it goes into somewhat of a black hole, which is difficult to follow until it comes out the other end at the Supreme People's Court. However, it has certainly engendered a very, very strong pro-enforcement mentality. Local courts are now minded to enforce awards. They do not wish to have awards or cases referred up the chain of courts only to be returned to them and decisions overturned. And this avoids the local favoritism and delays that are otherwise prevalent across the Chinese court system. It means that decisions which are rendered by the Supreme People's Court, which has the necessary expertise and experience, are well reasoned. Those decisions are now published and widely reported. There is, of course, no system of precedent in China. It's a civil law jurisdiction. But the Supreme People's Court does regularly publish guidance notes on issues that arise in enforcement cases. And those guidance notes are widely circulated and followed closely by the lower courts. As a result, the public policy exception to enforcement is very tightly defined and applied. You can have great confidence that an award, an international award, will be enforced in mainland China. The process may be a little slower than desired, but awards are enforced. Finally, on my last slide, I wanted to have a last word about Hong Kong, both about the enforcement of awards in Hong Kong and also Hong Kong as a credible international arbitration venue. Hong Kong has an English, has a legal system based on the English common law system. It is part of mainland China, and its relationship with China is governed by a piece of legislation called the Basic Law, which does defer certain rights, for example, in relation to international relations, defence and security, etc., to mainland China. But otherwise, the legal system is essentially self-contained. Hong Kong also has a modern arbitration law based on the model law with some quite useful additions. Its enforcement processes and the precedent on enforcement coming from the Hong Kong courts is world-class. The judiciary, notwithstanding all of the problems we have seen in Hong Kong and the allegations of influence by the mainland government, the judiciary does remain robustly independent. They have deep international arbitration experience and expertise. They are a world-class judiciary. So enforcement of awards is not controversial in Hong Kong. And likewise, it is a leading international arbitration centre. It has the HKIC, which is an excellent institution. It's at the forefront of thought leadership around the world. It has great people, great processes, very good set of rules, a lot of excellent practitioners in the city. It's convenient, it's English speaking. All of these things mean that Hong Kong is an excellent place to seat international arbitration. But I end with the question, is it enough? Unfortunately, given the recent problems and the assertion of greater influence by the Chinese government over Hong Kong, there is now a perception that Hong Kong is not as reliable as it once was, it's perhaps not as independent as it once was. And I fear that perception is to the detriment of Hong Kong as an international arbitration centre. I believe that truly international arbitration disputes, that is, disputes without a connection to Hong Kong or mainland China, will increasingly flow towards Singapore. Hong Kong will remain important, but increasingly focused on Hong Kong and mainland China disputes. And I think that's a real shame, because I truly believe that it is a first-class international arbitration seat. And with that, I conclude my presentation, and I'll pass over to Duncan Bagshaw, who's a partner at Kennedy's here in London. Thank you.
Thank you, James, and thank you to the LSLC for inviting me to speak. I'm going to say a few words about the enforcement of arbitration awards in Africa. This huge and diverse region, of course, can't be covered in detail in this time, but what I'm going to do is to start with a general view of enforcement across the continent, and then focus in on certain regions and jurisdictions, which I hope will represent interesting examples of the approach taken on the continent, and then finish with some points of general application, which I hope will be useful to anyone who's exposed to enforcement in the region. Let's start by taking an overview of the continent as a whole and looking at those countries which have adopted the New York Convention on the Enforcement of Foreign Arbitration Awards. As you can see from the countries highlighted in blue, the majority of countries in Africa have adopted the convention. Those which have not are generally those smaller countries and those countries in the earlier stage of their development. An outlier in that respect was Ethiopia. But as you can see, Ethiopia ratified the New York Convention as recently as the 13th of February this year and becomes the latest addition to the group of countries all over the world which have adopted the convention and therefore adopt broadly similar standards for the enforcement of international arbitration awards. I have two bonus prize questions which I hope some of you might attempt in the Q&A at the end of this, perhaps by making comments online. One is, two countries have adopted the New York Convention since Ethiopia, and I wonder if anybody can identify what they are. And finally, how many countries in total have adopted the New York Convention, including the two latest countries this year? Turning now to the OHADA region, many of you will know that this is the group of countries, 17 in total, which are members of the Organization for the Harmonization of Business Law in Africa. It represents an important group for our purposes because that group of countries has a unified system of arbitration law to which they all subscribe and a shared appeal court called the Cour Commune de Justice et d'Arbitrage, which sits as the appeal court for any matters under the Arbitration Act, the Act Uniform, and in particular deals with any challenges to enforcement decisions within the region. Enforcement of arbitration awards in the OHADA region is particularly specific because any award rendered in any of the OHADA member countries can be enforced in that country and therefrom across the region without any further action. That makes it a much more efficient process of enforcement than in most regions of the world. There have been recent developments, including in 2018, updates to the law which provided that an enforcement claim would be assumed to be granted if the local court didn't refuse enforcement within 15 days, a very rapid turnaround indeed. I should also mention the Mbulu Museso case. This is a case which updated the OHADA law relating to the enforcement of international arbitration awards against states, a very important subject, and provided that even if a state is a shareholder in a company against which an award is enforced, if the business of that company is a commercial activity, that means that the company will not be immune from execution. Let's look briefly at Nigeria, this massive economy which recently overtook South Africa as the largest on the continent. Under its Arbitration Act, the New York Convention applies to the enforcement of awards. There is a short limitation period of 6 years for the enforcement of any international or local arbitration award. The big issue to note about Nigeria is that the cases indicate a history of pathological delays in the court system for enforcement or setting aside of awards that can make it very difficult to get resolution and to secure payment of debts due under such awards. I was involved in a case called IPCO and NNPC. In that case, the award was given in 2004. It was an award that related to the building of the Bonny Petroleum Export Terminal. Judgment was never given, but the case settled in 2018 after the English courts were about to proceed to hear a commercial trial, which they only agreed to hear because the Nigerian courts, it was said, would not have resolved the set-aside proceedings in Nigeria within a generation. And for that reason, the English courts took it upon themselves to resolve Nigerian court issues. A similar case, AIC Limited and the Federal Airports Authority of Nigeria, has also been rumbling through the courts for many years. Last year, the English courts agreed to continue to wait and to stay any further enforcement proceedings whilst the Nigerian courts continued to consider the issue. The risk in Nigeria of cases being kicked into the long grass is a very serious one. South Africa has the benefit of a new International Arbitration Act, which was enacted and brought into force at the end of 2017. This was a long-awaited act because South Africa's law previously dated back to the 1950s. It brings the enforcement regime in South Africa into line with most international standards, applying the New York Convention rules and removing some restrictions on enforcement that previously applied. In particular, there were ministerial permission requirements for enforcing awards against the Republic and a general government public interest veto on the enforcement of awards that gave considerable concerns to international parties exposed to the enforcement regime until the new act came into force. A recent case where the new act was applied is the government of Tanzania and Spain, which came before the South African courts because the creditor in that case sought to seize, for the purpose of enforcing an arbitration award, an aircraft at a South African airport. The South African court in that case decided that it would release the aircraft and refuse to enforce the award because in Tanzania there had been a judgment which the South African courts took the view superseded and replaced the arbitration award, so that enforcement had to be under the regime for the enforcement of international judgments rather than arbitration awards. That was quite a surprising decision which attracted quite a lot of criticism, and it perhaps requires a few more years and a few more cases before the South African courts get fully to grips with their new legislation. Let's take a brief look at Kenya. Kenya is arguably the legal center in the East African region and one of the economic hubs for that area. Kenya has, as its arbitration law, the Arbitration Act of 1995, which incorporates the New York Convention with a reciprocity reservation. In other words, awards from jurisdictions which have themselves adopted the convention can be enforced in Kenya. The courts of Kenya generally take a advanced and international view of the New York Convention, and they often look to other common law and Commonwealth jurisdictions for guidance on the application of its provisions. One case of particular note in recent years is the Kenya duty-free case. This is a famous case that was decided by an investment treaty arbitration tribunal some years ago, who decided that a large cash bribe paid in a suitcase to a very senior government official of Kenya rendered the contract in question unenforceable. However, not deterred, the claimant in that case brought the case before a commercial arbitration tribunal in Kenya. And when that matter came before the Kenyan courts, unsurprisingly, and I think correctly, the Kenyan courts decided that they were bound by the decision of the ICSID tribunal to the effect that the contract could not be enforced because of the bribery, and proceeded to refuse to recognize the arbitrator's award which enforced the same contract. I'd like, if I may now, to consider Mauritius for a moment. Mauritius is a country which is close to my heart because I lived there for a few years and did some work on its arbitration regime and the arbitration center. Mauritius has the benefits of the International Arbitration Act 2008, which incorporates the New York Convention and has a number of advantageous provisions, including as its final course of appeal, the Privy Council in London, consisting principally of justices of the Supreme Court. It also provides that any enforcement application in Mauritius of an international arbitration award goes directly to a panel of 3 judges of the Mauritius Supreme Court. That ensures that there is both consistency and a high level of consideration of any applications for enforcement. Some interesting recent cases include the Betamax case, in which the Mauritian court refused to recognize an award which had been granted to enforce a contract which the court felt had been granted in breach of the public procurement rules in Mauritius, which was said to be a breach of public policy. That case may well come before the Privy Council in London in due course. Secondly, the case of People Capital Fund, which was the first case under the Mauritian Act to come before the Privy Council as recently as last year, in which the court roundly dismissed an application to set aside an award on the basis that the arbitrator had somehow misled or wrongly conducted the arbitration to the detriment of one of the parties. I'd like to finish by discussing some general points which I have found helpful to keep in mind when considering enforcement of arbitration awards in Africa. The first is the significance of states and state entities. And on our subject, the key concern, of course, is dealing with the risk that a state or a company owned by a state may claim that it has immunity from execution, and therefore no award can be enforced against it. The best way to deal with this, of course, is at the beginning of a transaction by way of clear written agreements, making it clear that if a state is a party, or if a company owned by a state is a party, it will not benefit from any immunities against the execution of the awards rendered by the arbitration tribunal provided for in its dispute resolution clause. The second point is that there is a high risk, as I mentioned earlier, of local set-aside proceedings or enforcement proceedings being kicked into the long grass by perhaps inefficiencies in the system or by lawyers in the jurisdiction who know very well how to use the local appeal system to avoid any final judgment being rendered. One way to deal with that is to bring proceedings in a jurisdiction which you know may be more efficient, seeking a resolution of those proceedings before going to any jurisdiction where you think there may be delaying tactics. Thirdly, there is the question of what I like to call the fiscal counterattack. That is to say, where enforcement of an arbitration award is rendered of no value because when the money is secured, or even before, the taxation authorities in the jurisdiction seek to impose punitive tax demands or even dipping into bank accounts, which happens in some jurisdictions, to remove the benefit of any award. My best suggestion to deal with that is to try to ensure that the proceeds of an award are paid directly into a bank account outside of that jurisdiction and hopefully beyond the reach of the taxation authorities. Of course, I don't encourage anyone to ignore their taxation obligations. I'm talking about the situation where taxation demands are being made strategically for reasons which are considered not to be legitimate. The fourth point I'd like to make is that fraud and corruption remain an issue in Africa, but I would suggest less of an issue than they have been for many years. Most governments on the continent are recognizing the issue and taking steps to deal with it. Most courts in the region will not allow fraud and corruption to taint proceedings before them for the enforcement of arbitration awards, and the presence of international courts like the OHADA court and the presence of a right of appeal to the English court from Mauritius, for example, can be ways to mitigate any concerns about corruption. Finally, one tip that I would give for consideration, which I mentioned in relation to the delaying and the long grass approach that can happen in the enforcement jurisdiction, is to select your first jurisdiction for enforcement quite carefully. That may be an African jurisdiction, but it may not be the one in which you ultimately plan to find assets against which to secure your arbitration award. Where you have within one region, like the East African region, a more efficient court, like, for example, the courts of Kenya, you may choose to go to that court before going to your ultimate destination to seek to get within an efficient time a positive decision, which you can then take with you when you go to a more difficult jurisdiction as a way of hopefully speeding up the process and giving the local courts encouragement that it is the right decision to enforce your award. That concludes my remarks. Thank you so much for listening, and I'm happy now to pass the baton back to Sir Robin Knowles for the live Q&A session.
Good afternoon. Good afternoon. It's Robin Knowles speaking now, and we're now into the live Q&A. We all know how important enforcement is as a subject. It goes to the rule of law. It's at the heart of effective international business. I'm hugely impressed by and grateful for the contributions that we've had. I'm also hugely impressed by and grateful for the questions that have been put in writing in the course of the webinar. Answers to those questions that we're not able to cover in the short period of time for live discussion will, I'm told, be able to follow in writing afterwards so far as possible. So please look out for that even after we've completed the discussion. Can I go straight into a few questions for now, though? Sherina, thanks for what you told us about the developed approach in India, but what about the expedition with which the Indian courts will handle their decision making about arbitration enforcement?
Thank you, Sir Robin. I believe, given now the pro-government stance and the and the judiciary stance on expediting arbitral awards, the idea is that it will be done within 6 to 12 months. Much is to be seen, but I think that is hopefully where they are heading towards. So 6 to 12 months.
Thank you very much. James, again, thank you for your contribution across China and beyond. Can I ask this question, and I may come on to the others with the same question as well. If a decision is reached that an arbitration award should be enforced in China that has come from another part of the world, are all types of enforcement available, or is the list of types of enforcement that will be made available restricted?
That's a very good question, and I'm not sure I'm qualified to answer that. My experience has not got that far, where when we've sought to enforce awards that have been challenged in China, ultimately they were recognised and paid. So I can't comment on those specifics, I'm afraid.
No, that's fair enough. Thank you for what you have told us. Let me move on to a different question with you, James, if I may. And it involves looking forward and your best prediction. With the interest in Belt and Road, very, very close to China's heart, do you see that as having an effect in the future on its readiness to enforce arbitration awards that have come from other jurisdictions?
Well, I think China has moved a long way in the last 10, 20 years to ensure that it does recognise and enforce awards from other countries, because it recognises that it is a exporter of capital now, and its own companies and individuals will want to enforce awards overseas. So I think that move has already been made.
Thank you.
And obviously the Belt and Road initiative just reinforces that idea. And, it means that China's not going to regress anytime soon when it comes to the enforcement of international awards.
Thanks so much. If I can move across to Duncan with a question, if I may. And Duncan, it's this: in your overall experience and assessment, to what degree are the courts courts in Africa that are having to handle arbitration enforcement questions using a specialist judiciary, or a judiciary that's had particular training in that area?
Thank you, Sir Robin. There are only a few jurisdictions, to my knowledge, where there is a specialist or designated judiciary hearing international arbitration cases. One is Mauritius, where of the Supreme Court judges, there is a small panel who are exclusively designated to hear the cases on the International Arbitration Acts that come before them, including enforcement of foreign awards. I don't think in any other jurisdiction is there a small, exclusively designated panel. However, there are in other jurisdictions rules which limit the judges that can hear such cases. For example, in Kenya, it has been decided that any appeals on issues relating to international arbitration go to the Kenyan High Court, and there are certain judges who deal with commercial issues, and that there is no further appeal available from those judges. What that means is there is a certain consistency in the identity of the judges hearing cases, so that they generally come to a fairly coherent body of jurisprudence on the subject. In other jurisdictions, it's much more difficult. In Nigeria and South Africa, for example, constitutional limitations on restrictions on judges and appeals make it hard to keep the pool of judges down to a low level. So it's only a very few jurisdictions where there's a truly specialist judiciary so far.
We do know that within Africa, the number of countries that are developing a commercial court or a dedicated commercial dispute resolution capability is increasing. And indeed, a good number are now members of the Standing International Forum of Commercial Courts. Does that hold forward promise, do you think, or does it not matter so much that there should be specialism focused in a particular group of judges?
My own view, although of course I should acknowledge that I'm not an African lawyer, and lawyers from each jurisdiction will have more on-the-ground experience than me, but my own view is that it's hugely beneficial to have either a designated pool of commercial judges or, even better, specialist arbitration judges hearing cases. And I know from speaking to the judiciary in certain jurisdictions, I've done so in Nigeria and Kenya specifically, that there is a desire and a drive to increase the specialization of judges, and there's a recognition that there's value to doing so. So I think we can expect it to happen more and more in the coming years.
Thank you. Francis, you very kindly started us off and then had the benefit of hearing the cross-continent coverage of our other contributors. What one or two things would you say are important for the future success of the New York Convention in arbitration enforcement?
Well, I think it just goes back to the question of states taking arbitration seriously. As we know, arbitration is a creature of contract, and as states sign and ratify the agreement, and as they continue to become more and more familiar with it, I think we continue to see domestic courts taking arbitration awards more and more seriously, and not or being more reticent about setting them aside on the grounds of public policy, and that touches on the point that Sherina made earlier. And I think going forward that should continue, and hopefully we're seeing that already, and I see no reason why that shouldn't continue.
My thanks. We are close to being out of time just on the short and live Q&A, but as I said, the discussion can continue online with the written Q&As, and I hope it will. Can I chip in what was a comment from one of the many people across the world that have been listening? It comes from Ian Gaunt at the LMAA, and he wished to observe that in China, the experience of the LMAA is that very few awards have been refused enforcement. That's a positive note. Thank you for that comment. But a positive note on which to end. What really has been an insightful hour or so. I know that those on the panel will join me in thanking those who've arranged the logistics, led, I think, by Grace from Norton Rose. But all of our thanks, attendees and panelists, are really due to the London Shipping Law Centre for identifying a subject of this importance and making sure we have a dialogue of this depth in times that are as challenging as they are at the moment. We all wish everybody well in these times and look forward to working together. Thank you very much.